If you are disputing the validity of a will, that's a challenge against the will itself. Can you tell me a bit more about that?
Yes, certainly. I mean, those claims are not as easy to prove. I mean, they can be technically quite challenging and difficult, but you can claim under grounds such as perhaps you think that the will hasn't been correctly executed. So we said at the beginning that it needs to be in writing, it needs to be signed and appropriately witnessed. If any of those things have not been carried out properly, then that allows for a technical challenge to the will and its validity. There are other situations where perhaps you think that the person making the will didn't have sufficient mental capacity, and that would involve things like perhaps they're suffering from some kind of illness, dementia, Alzheimer's, that kind of thing. That doesn't necessarily mean that they wouldn't have what we call testamentary capacity, so that's the ability to make the will, but it's all about a question of degree. So we certainly do have cases where people may have mild dementia or mild Alzheimer's and they're still perfectly capable of making a will, and the things you have to bear in mind for that are they aware of what they're doing? So are they aware of, the fact of their estate, the fact that they're making a will, what that means to make a will? Do they understand what's involved in the estate, what assets they're actually passing and who they're actually passing them to? If they can demonstrate that they're fully aware of all of that, or really just aware of it, not necessarily fully aware, then they will probably have sufficient capacity.
So again, akin with Inheritance Act claim, there's an awful lot to consider when it comes to this.
Yeah, there is.